Sí, perfecto. Sí, proyecta ahí, quiero ver si... Sí, listo. Listo, entonces... Igual lo del horario, si en algún momento está como en la mitad de un capítulo, seguimos y podemos hacer una pausa de 10 minutos, no hay
Lo
problema.
que voy a necesitar tu ayuda es, porque lo que voy a tratar de hacer es demasiado para el tiempo que tenemos.
Sí.
Son 2 horas, ¿no?
Son, sí, hora y...
Entonces
o sea,
hora y
son
media. Bueno, por el break.
12, exacto, por el break. Pero igual se puede hacer una pausa de 5 minutos en vez de 15. Está perfecto, a veces la profesora...
Lo poco que me digas es, no debería hablar más de 20 minutos o tratar de no hablar más de 20 minutos de cada uno de los artículos.
Ok, listo.
Si son las que me estoy atrasando mucho, me hace seña y
Listo.
tengo que seguir.
Porque aquí vamos a ver los 4, que son 4 de 20.
Sí,
1, 2, 3.
Con el 3 vamos es muy grande.
Muy extenso.
Es demasiado lo que tenemos que hacer, entonces lo voy a tratar de hacer un poco light.
Igual el 21 se puede hacer un pelín más comprimido al final.
El 21, ni 20 ni 21 vamos a tocar, pero el 11 sí tengo que explicar de qué tal.
Ok. 11, perdón, sí, ok. Pero ese puede ser un pelín más corto de pronto si el 3 no podemos hacer espacio.
Vamos a ver.
Pero ahí voy intentando, listo.
Trataremos.
Listo, bueno, eso entonces. Good afternoon, everybody. So, as Professor Marceau announced last week, we're going to have the privilege today of having her colleague from the WTO, Mr. Roy Santana, with us today. So, brief introduction to him. So, he worked for the Costa Rica's government as a counselor at the foreign trade, Ministry of Foreign Trade first, and then at the permanent mission of Costa Rica to the WTO here in Geneva. He also teaches several classes on WTO law, first at the Graduate Institute and now on the World Trade Institute in Bern. It's still the case right now. And he has a 20-year experience at the WTO now, so he currently is a counselor and secretary of the Committee of Market Access. So yeah, as you can understand, it will be a privilege for us to have such an expert for this specific class today. So that being said, the floor is yours, Mr. Santana.
Thank you, Felipe. How are you? Fine? Okay. Let me tell you a few secrets. First and foremost, I am not a university professor. I am mostly a trainer. So my job is mostly to go around the world. I work with government officials, sometimes with people from customs. And then my job is to make sure they learn some of the basic principles we're going to be discussing today. In fact, I asked ChatGPT, draw me something for the 4 pillars of the GATT, and it took it a bit too literally. But I found it was funny. So we're going to be discussing the 4 pillars of the GATT and how this relates to the, in particular, market access type of conditions that governments provide one to the other. The second confession I have to make to you is I am trained as a lawyer. I am trained as an economist. I do not work as either. The lawyers think I'm an economist. The economists think I'm a lawyer. So I don't know how that speaks about my education. But I'm going to try to make it as interesting and entertaining to you as I find it. I'm very, very passionate about these issues. We're going to see that these elements are extremely relevant for what's happening today in the world of trade. Yeah, and in fact, I try to put that in terms of a question, right? In terms of whether these are relics of the past. Imagine, on top, we keep having these references in Roman numbers. Most people do not even know how to read Roman numbers anymore, right? How many of you know how to read Roman numbers? More than 10? Okay, we'll see. We're going to have a little test on that at some point as well. Any question before we begin? No? Okay, so let's begin. So I have the impossible task of explaining to you these 4 articles. Each of them is incredibly complex. We have sometimes courses that deal with each of these agreements, and you can spend 2-3 days only talking about the legal details and all the specifics of some of these issues, what has been said in the jurisprudence, etc. But then my job today is just to walk you through the very, very basics in terms of how we read these legal provisions, right? We cannot run before we walk. So today what we're going to be doing is taking baby steps. For me, it's very important to have some form of interaction. I'm very intimidated by such a huge class. How many are you? How many are they, Felipe? 80, yeah. Well, normally I teach like 20 people, so it's the first time I have such a huge class. Let's see if we can have a bit of a conversation with some of these issues, right? Because otherwise it becomes very boring if I just talk. Who agrees with that? Okay, you're supposed to raise the hand, right? Okay, so I have grouped the issues we're going to be discussing in 3. So we have this non-discrimination aspect that Gabriel told me you already discussed. So this non-discrimination, you probably already saw, includes 2 different aspects, one in terms of the national treatment and another one in terms of the most favored nation. So today we're going to see how that is written in practice. How do we actually analyze this huge complicated text that we typically have in front of us? Then we're going to move into these member-specific obligations and this concept of schedules of concessions that we have in Article 2 of the GATT. And finally, I hope we have time, so Felipe's job is to keep me on track to discuss everything, is Article 11 of the GATT, which to me is the most interesting, most fascinating provision we have in the GATT, and I'm going to try to explain to you why I think that's the case. Okay. Before, I just wanted to tell you, and this is something when I was studying these issues, I wish somebody would have told me why this is important. So the provisions that we have in the WTO are not there just painted in the wall. They are very actively used by the WTO members to challenge and question some of the measures which are being introduced by the other members, right? So for example, you have China complaining against the United States. Why are you blocking those exports of microchips that can be used for artificial intelligence? We believe that this is just purely protectionist, and the US says, no, because I need to do this to safeguard my national security, right? So you read the newspapers, right? Yeah, so you are aware of all these huge issues happening in terms of world trade. This is one of them, not the only one, where I'm going to be making reference to some of them as we go along. Now, in the WTO, we have different, it's kind of like an escalation of the issues, right? So in principle, you begin complaining bilaterally, for example, through the embassies. Once this fails, we have these committees. We have different bodies that are in charge of different issues. Once this fails, you actually take the issues up in the hierarchy. And when it comes to goods, you will go to something which is called the Council for Trade in Goods. So in fact, that's now my main job. If that fails, you would not take it to the General Council. You would normally launch a formal dispute. So what I have here is, in terms of the actual complaints that we have had in the Council for Trade in Goods and the disputes that have been launched, how many times they actually use some of these agreements. And as you can see, the GATT is still the king of the legal instruments when it comes to challenging the measures by the other members, right? So even if you look at the disputes, in 80% of the 627 disputes that we have had, there is some form of claim of the member saying that the other member is in violation of the GATT, right? So when it comes to litigation, when it comes to challenging the measures by the other members, the GATT is the main instrument, the main legal agreement that we have for this. That's why sometimes it feels like, but why do we look at the GATT if we have all these new agreements, if we have all these new even free trade agreements or customs unions, right? Well, interestingly, many of the provisions we're going to be discussing, if you are signing a free trade agreement, what they do is they actually incorporate, they take this provision from the GATT and put it directly into their agreement as well. So even if you are looking at free trade agreements, these provisions are relevant and they are important. Now, within the GATT, I just did this calculation for something else, but I thought you were going to find it interesting. Which are the main provisions that members use to challenge the measures by the others? Guess what? The top, or at least the top 3, are some of the things we're going to be discussing today, right? So in terms of relevance, guys, this is it, right? So this is really the provisions. Even if you don't learn about anything else, these are the ones that you need to really make sure that you understand properly. Now, let's talk about non-discrimination. You already discussed this with Gabriel, right? What do you remember? Okay, I'm glad Gabriel is not connected because otherwise she's going to be very disappointed, right? So what do you remember from what Gabriel said? Speak loud.
Yeah, I think for the principle of non-discrimination, it could be examined from 2 perspectives. The one is there should be no discrimination between the domestic products and the imported products. And so it's also about the national treatment principle. And the other aspect is we have to treat, for the members, for WTO members, they have to treat they have to give the same benefits or accession to all the other WTO member countries. So it's about the most favored nation principle.
Yeah, and then when we are talking about trade in goods, these principles can take many different forms. We're going to be looking at the main basic forms of these principles, but then, for example, if we have other agreements, they're going to have different variations of these principles. They try to translate those, let's say, basic elements into the specific agreement, right? So, for example, TBT has MFN and national treatment provisions. SPS has MFN and national treatment provisions, etc. But then we're going to be looking at the very, very basic ones that apply in general terms, right? We also have, when it comes to trade in goods, we're really looking at goods that cross the border from one place to the other. There's now a big discussion as to what about digital goods? Are they also covered by the GATT or not? What do you think? Does a good need to be physical to be a good? Do you consume any digital good in any way? Okay, guys, how many of you have Spotify? How many of you watch YouTube? Is that a good? Is that a service? So you have sometimes discussions around these issues. To the extent that they were goods, the rules that we're going to be discussing would also apply to them. Okay, so let's talk about Article 1, and the name of this one is the General Most Favored Nation Treatment, right? So this is a general provision, but as I told you before, we have other specific ones that deal with this as well. And then, I don't know how many of you have actually done it. You can go to the WTO website. We have one part where we have the legal instruments. There you can find the GATT. And then you open Article 1, Paragraph 1 of the GATT, and it looks like this. And what's your reaction when you see something like this? First time I saw it was, oh my God, didn't they know about punctuation? Look, all of that is one sentence. Right? One sentence. I really would have liked to know the person who drafted this, right? Now, how do we read? Because you are lawyers, right? So our job as you're not lawyers? Okay, how many of you are lawyers? Okay, I had the impression we were in a LLM course. No, but it's not the case. So what do you study?
I studied international relations. Now I'm studying sustainable societies and social change.
Oh, okay. So I apologize in advance because the class is going to be very difficult for you. You're going to learn how lawyers see the world, which is in a very, very peculiar way, right? So any of the lawyers, which is about half of the class, how do we read these things? What do we do? Because you explained already more or less what's supposed to be the general principle, but how do we actually read it, right? How it's written is important. Why? You were raising the hand around here, somebody? No? Yes?
We have to follow someone's interpretation because this is a treaty. So we have to apply the Vienna Convention on the law of treaties following a step-by-step
Let's not go there. Let's just imagine that we are just trying to read and understand this. The rules are important. Why? Because they set the limits of what we can do and what we cannot do, right? How the rule is expressed is extremely important, right? Because depending, and then if you are looking at anything we do in real life, if we're looking at a contract, if we're looking at criminal law, if we're looking at what the governments can do or not do, everything is in written form, and then you have the boundaries of what you can do and what you cannot do, right? So what are the boundaries of what we can do and what we cannot do under Article 1 of the GATT? I remember who raised the hand and said they were lawyers. Yes?
Well, you have to look at the conditions of this article, because there are different conditions, and it states what the government, well, what the WTO members can do, which is to provide an advantage to one of the WTO member and not provide that same advantage to the other members.
Okay, can you help me just kind of like describing the text? What does the text say? It's a long sentence, right?
If you divide it, you see that there's
You divide it how? What are the components?
you look at the, well, there's an advantage favored to the immunity granted, so that's the first condition, it has to be that, and then, you just read it and you see the different conditions.
Okay, let me try to split that. Okay, so for the lawyers and for the non-lawyers as well, if we're trying to read these super complex things, first advice I have for you is you try to split it into kind of like different elements so it's easier to understand, right? So what is it that we have in the text in red? You were going very well. So what do we have in? You. No, sorry, her. She was doing very well. Now we did what you wanted to do. So what do we do?
Well, we look at the, like, these are the different conditions. So first, it states the scope of application, so that it has to be in connection with implication or expectations. We need to be in that, we need to have
Something very important. The MFN principle does not only apply to imports, it also applies to exports, right? Okay, what else?
always, which is different from national treatment.
And then that text in red is what? You said the scope in terms of what? Application, but you have this list of custom duties and charges of any kind imposed on or in connection with importation or exportation, or imposed on the transfer of payments for imports, and with respect to the methods of levying such duties and charges, and with respect to the rules and formalities, and with respect to all matters referred to in paragraph 2 and 4 of Article 3. So on top, there is an external reference to something else, right? So what are those? These are specific measures which are covered by the scope of what we have in Article 1, right? What happens if it's a measure outside of the list?
The article would not apply.
Exactly, right? So if we're dealing with a measure which is not covered by what we have there in the red text, it's out of the scope of Article 1. Right? So understanding the scope of what falls under Article 1 is extremely important and is defined by that little red text, right? You want to continue. What about the next one? The advantage part.
So we see the conduct that we are referring to.
The conduct by whom?
The condition, the conduct by a WTO member state.
Remember, this is an obligation for WTO members, right? So if you are a WTO member, you must abide by this. So what's the obligation for the WTO member with respect to all those measures in red?
So when they grant such advantage, favor, privilege, or immunity, they have to grant it to other member states too. So to third member states.
If they grant it, to whom?
If they grant it to any WTO member.
Is that what it says?
To a product.
It says for any other country. Let me give you one example. How many of you like pistachios? Okay, which is the country that produces the best pistachios?
Turkey.
You're going to be disappointed. I was going to say Iran. So Iran has really fantastic pistachios. So imagine Switzerland says, you know what? I'm going to have a tariff for WTO members, which is 10%. And those pistachios from Iran, they are so good. I'm going to have a 0% tariff for the Iranian pistachios. Can Switzerland do that or not? What do you think? By the way, Iran is not a WTO member.
Would say no, because that says any other country, and therefore might not only be a member country, but any other country.
Exactly. So you see, the way things are drafted are incredibly important, right? Who has the obligation, Iran or Switzerland? Switzerland, right? Iran is not a WTO member. They don't have any rights, but they don't have any obligations, right? So Switzerland, as a WTO member, has this obligation of not granting advantages, favor, privileges, or immunities to, does it say to all the other WTO members or any other country? And because it says any other country, this extends to preferences that you give to those countries which are not members of the WTO. Right? So a situation like the one that I described would not be possible. Why? Because it's extending an advantage to Iran that you are not giving to the other WTO members. Is it clear? What about the last part? Go ahead.
Well, then it says that shall be accorded immediately and unconditionally, so this is one of the conditions on how the state has to act. And then the final consequence,
Yep.
like product originating or in or destined for the territories of all other contracting parties. So that's the legal consequence. That's actually what has to be done and what can be demanded.
Yes, and then here the idea would be Switzerland as a WTO member, if you are given a lower tariff to Iran, you have to give it immediately, unconditionally, also to all the other WTO members. Now, what happens if they don't? For example, imagine this is a real situation, and then Switzerland gives a lower tariff to the pistachios from Iran. Who's going to complain? Whose job is it to tell Switzerland, look, you're not complying? Yes?
The other member state?
Is it the WTO Secretariat? No. So it's not my job to do that. You're exactly right. It's up to the other WTO members to basically examine the policies of the other members, and if they think that they are in violation, then we have these different steps that I was mentioning before in terms of calling the other members into order and telling them, please align your policy with respect to the rule that we have here. And imagine you are working for Switzerland, and then, sorry, not for Switzerland. Imagine you are working for Turkey. Another exporter of pistachio, they're very upset for this discrimination, right? So how would you argue that there is a violation of this article? You are contacting Switzerland and you tell them what?
I will prove to them that they gain the advantage to Iran and say you're not granting the advantage to us, and there is a discrepancy, and according to Article 1, this is a violation.
When it comes to dealing with this type of provisions, the language is extremely important. So basically, what the lawyers would do is they will take as much as possible of the language that we have here, right? So for example, you would probably begin by saying something like what you said, but then if you want to be technically precise, how would you phrase it using this language? Any volunteer? You were there in the back. I'm not sure if you're still volunteer or not.
No,
Not this time? Okay. Any volunteer? How would you say it? Yes?
I think it's a custom duty with importation.
Yeah.
If Switzerland levy zero duty on the products of Iran. So if I am an attorney of Turkey, I would say that it was a custom duty international with importation.
So you need to do a comparison as well, right? So you need to know how much they are charging. First of all, custom duties, are they covered by the scope of Article 1? It's the first one, right? Okay, what else? Are you giving an advantage to any other country that you're not giving to the WTO members? This one implies a comparison, right? A comparison of what? You were going well.
Yes, I think it's advantage and favor for the Iran, because Switzerland want more products, so it grants an advantage to.
And the advantage takes the form of a 0% duty when the rest of us have to pay 10%.
Yes, so compare with other countries, Iran
And therefore, your request to Switzerland is what?
I request Switzerland grant the advantage to other countries.
And that means give me a 0% duty now, right? It's not tomorrow, it's immediately and unconditionally, right? And do not even think of asking me anything in exchange for that because you're already giving it to somebody else. This provision was extremely important. It's one of the main reasons why, you remember the GATT began as a little club, only of 23 countries. And then if you were inside, basically anything that was given to anybody else would have to be given to you. But if you were outside, you were in trouble, right? Because even negotiating with any of these members was a problem, because if they gave you anything, then all the other members of the club would also be getting it, right? So this created a very big incentive for all the other countries to try to join the GATT as well. Now, there is one part here, the part in green, that talks about this concept of like products. Have you heard about this before or not? So are the pistachios from Turkey like to the pistachios from Iran or not?
Then there are different characteristics to allow you to look at the end user products, consumers' behavior, characteristics.
This is one of those issues where the lawyers in the disputes have so much fun. They have questions like, you know, are the cigarettes that have menthol, are they like products with respect to the normal cigarettes? Is whiskey made out of sugar cane the same as the whiskey made out of rye or not, right? So there's always these questions as to whether the products are like or not. Now, one thing I just wanted to show you, I told you that there's different versions of MFN, right? So this is a simplified version of Article 1, but now let's look at Article 13. And this one is about the non-discrimination in respect of the application of quantitative restrictions. And I don't know if you see this, but it's more or less the same. But this one is not talking about favors, privileges, or immunities. This one is talking about prohibitions or restrictions. So if you restrict the trade of one, then you should do it the same for the others. Right? So this is another variation of an MFN principle, but then is slightly more specialized, different from the general one that we have in Article 1. I just wanted to show you, does this happen in real life or not? So this is the tariff schedule of the United States. This is the tariff that they actually apply in practice. This probably looks very intimidating the first time you see it, because you need to learn, you need to know a lot. You have this big part here that is based on something which is called the Harmonized System Nomenclature, which is administered by the World Customs Administration. It's a whole world on its own. There are people who specialize only on the classification of chocolates, just to give you one example how specialized it can be. Then it tells you what is, in the US they call it general rate. For us, we call this the MFN rate. This is the rate that they charge to WTO members. And sometimes it happens that they actually charge other duties to products originating in other members or in other countries. And here, for example, it says free. What do you think free means? Free chocolates. Free means what? Yeah, have you heard of the concept of duty-free when you go to the airport? Yeah, duty-free means 0%. That means that you don't have to pay tariff, right? And who is it that doesn't have to pay tariff? The products originating in AU, sounds like? Australia? Okay, I can see you don't know the ISO codes. So that's Bahrain, Chile, Colombia. Then you also have Israel, Jordan, Korea, Oman, Panama, Peru, Singapore. And why do you think the US is giving lower tariffs to them? So many of these relate to free trade agreements, or they may also relate to unilateral preferences given by the United States to help some of these countries. You have, for example, the generalized system of preferences, You also have something called AGOA, where the US tries to help African countries so they can promote their exports, etc. But then I have a question for you. How come MFN, most favored, right? Is the US given a tariff which is lower to other countries which is not given to WTO members? Okay. Which one is bigger? You remember the alligator from school? Okay, which one is bigger? So how come WTO members are paying more than some other countries?
Is there some exceptions that people can consider?
Okay, Felipe, I'm in trouble now. How do I erase it? Maybe the bar is here. We need to escape. No, ignore. Okay. Okay, yeah, exactly. So we have some exceptions, right? How we look at the different issues in the WTO has a very, very specific order. And then, sorry, I'm gonna do it again. We have a name for that, which is, it's an easy way to remember. It sounds like a medicine, right? MEVIX. The first thing you are supposed to look is at what's the measure. Once you know what's the type of measure, then you know the type of provision that applies to it. For example, if you are given a lower tariff to one country that you are not giving to WTO members, you know we're in the realm of Article 1, right? Once we know that, then we see if there is a violation. And then if that's the case, then the next thing we have to analyze in third place is whether there is an exception that actually allows me to deviate from that rule, right? And I am only in violation of a WTO rule if it's a measure covered by the agreements which I am prima facie violating, and there is no exception that allows me to apply it. Right? But then you need to do it in this order. And in this particular case, we have plenty of exceptions for the MFN principle. In fact, some people say that MFN is a bit of a joke, is a misnomer, because in fact the MFN is typically the worst tariff that you have to pay. So instead of being the most favored, typically it's actually the worst favored nowadays in many countries. Now, in the case of the US, that's not really true. That's an easy way to delete, because there's another one. So in the case of the United States, they have a third type of duty, which is the one that they levy on the non-WTO members. So for example, if you are Iran, well, Iran, I doubt is going to be exporting chocolates to the US for other reasons, but imagine they were trying to export chocolates to the United States, you will need to pay a 40% duty. The US is quite unique in this respect. I don't know if you have seen how the European Union call their tariffs. They don't call them, you remember we were saying that this is MFN, right? In the European Union, you will never see in their legal instruments, they never call it like that. They call it erga omnes. Oh my God, and now they bring the Latin. That means what? It's to everybody, right? So for example, if you were exporting to the European Union, the tariff is the same for WTO members, but also for Iran and all the other countries which are not part of the WTO, right? So there are these kind of like little nuances in practice. Okay, what do I do? No, I think do this, and I do ignore it. Okay. Okay, so let me say that again. Who wants to say? If we want to analyze any situation, what's the order in which we need to look at the issues? Yes.
Measure, violation, exception.
Exactly. So we begin by the measure. We have to see if there is a violation, and only at the end we look if there is any exception, right? There's a whole issue in terms of what's the right way in which you have to interpret the provisions, whether the Vienna Convention on the Law of Treaties that you were mentioning before, is that, or is it the customary principles of international law which are reflected in there? You know, lawyers have a lot of fun discussing for hours these things. We're just going to keep it very simple, and I'm sure Gabriel is going to be dealing with all the technicalities later on. Some of you may have even discussed some of them in courses you had before. Now, I like to simplify things. So if we look at the jurisprudence, typically they have a three-tier test to examine if there's a violation of Article 1, and then the first thing they look at is exactly what you were doing. Very good. Is there a trade advantage in any of the 8 type of measures that we have covered, you remember, in the red text? Are they like products? If they are like products, therefore the consequence is that, yes, we have to extend immediately, unconditionally, the preference, right? So the lawyers have a lot of fun bringing arguments, trying to explain why this is not covered by the measures, why they are not like products, and why they don't need to extend it immediately, unconditionally to the other members, right? So if you're a lawyer, typically, you know, they try to address all these different issues to have a defense. Any question? Okay, let's see. Okay, so I'm told that you already discussed the whole issue of like products, right? So is Coca-Cola a like product with respect to Pepsi or not? And with respect to water? And with respect to beer? The tricky part with the like products is that it's a bit fuzzy, right? So it's like, you know, some things are very clear, but then the farther you keep going away, it can become a bit more tricky, right? So I'm going to skip this. You already discussed the 4 conditions as well, right? For determining whether products are like or not. Okay. Let me give you one example. And this is a very popular issue right now. So you have these 2 tomatoes. One of them is organic. Can I treat these 2 tomatoes differently? If you look at them, they are exactly the same. The only difference is how they were produced. In other words, imagine that I'm Switzerland and I want to allow organic tomatoes from the European Union to be imported at a lower rate, and I want to discriminate the tomatoes which are not produced organically. They are produced through, let's say, normal means using pesticides. Can I do that or not?
I mean, it does, first of all, depend on the scope and the definition, but I would say, like, it's from the
Scope and definition of what?
From the view of the, like, as what you, the definition of, like, the margin of tomato, but I would say it's about the view of the consumer. So does it influence their choice, or would they treat those tomatoes alike? Like, if they buy the tomatoes, that influence the buying choice, so therefore are the tomatoes interchangeable or aren't they?
Main issue when we're looking at the like products is whether these 2 products compete in the same market. I don't know if any of you, in terms of the lawyers, if you studied competition law, there is a whole discussion on how you define the market, etc. This is more or less the same type of exercise, right? And our jurisprudence has basically focused on 4 type of elements. So you will need to look at the characteristics of the product's nature and the quality. 2 tomatoes, you cannot really tell the difference from one from the other. So let's suppose that one is not applicable. The end use of the products, what do you do with the tomatoes? Okay, we eat the tomatoes, right? Or we prepare sauces, or we use it for some other purpose, right? The tariff classification of these products, well, they are classified in the same place. And then we have the 4th one, which is the taste and preferences of consumers. Do consumers see these as different products or not? One challenge that many disputes have is that typically the answer is not clear-cut. It's very, very rare when you have a situation where the 4 of them say yes or no. Typically, some of them say yes, some of them say no. And then here, the idea is that the panel is supposed to do a holistic type of analysis to arrive to the conclusion, which is typically, you know, whatever the panel feels is right for this particular situation. This is done on a case-by-case basis. It used to be that this type of situation was the most controversial, but now we have an even more controversial. Imagine that the two tomatoes are exactly the same in any way. They are not even called organic or anything, but then one of them was produced emitting a huge amount of CO2, and the other one with lesser amount of carbon emissions. One of them might even be carbon neutral, and the other one is not. Are they like products or not? What do you think? The European Union is implementing something called the Carbon Border Adjustment Mechanism, where they basically want to differentiate steel, aluminum, and other products based on whether they emit, on the amount of carbon that they emit. If they emit it above a certain amount, then there is some form of adjustment, and then they have to pay for that. Yes?
I would say they are like products, even if they their production method is different, because simply there is a specific provision for the different to have an exception for this kind of situation.
Okay, but remember the order, right? Measure, violation, exception. When we are talking about like products, we are not talking about the exception, we're talking about the violation part, right? So if the conclusion is that the two products are like, then what's my obligation? Okay, let's go back to the text of Article 1. Let's suppose there's a country that wanted to discriminate these products and treat them differently. If we determine that they are like, and you're really giving an advantage to one that you're not giving to the others, then the conclusion is that there is a violation, right? If the conclusion is no, they are not like, then you do not have the obligation to extend the advantage to the other product because they are considered to be different. Right? So it's a very, very key point for this purpose. When it comes to carbon emissions, very highly contested whether they are like or not. Yes?
I just wanted to say, answer your question for the consequence.
Yeah.
So if there would be a violation, as long as there's an exception, you must grant the same advantage immediately conditionally.
Exactly. So if they are like, then I have to treat them the same, right? That's the conclusion. Okay. Sorry, I get too excited on these things. Let's move on to, what time is it, Felipe? Am I? So we stop now? Okay, we go a little bit more and then we can stop. In terms of explaining the provisions, this one is the most difficult because there are 4 different elements which are here. So it's not one, it's 4 different elements. I'm not going to go into the nitty-gritty of how it works because it takes a lot of time. It's very difficult. So I just want to teach you how to read it and give you a sense of the 4 different elements which are here. Okay? So I don't know if you noticed, but when we were talking about Article 1, it was all about border type of measures, right? Most of the times. Here is really not about border type of measures. We're talking more about internal type of measures. So typically it's a situation where the product has already been imported into the country. Can I treat it differently or not? Can I treat it differently from what? Can I treat it differently with respect to the treatment I give to the national products? In what we were looking in Article 1 was a comparison of the treatment of products from members, right? Switzerland versus Iran, Switzerland versus European Union versus Turkey, etc., right? When we are in Article 3, it's not about comparing members, it's about comparing the external product, the imported product, vis-a-vis the national product, right? Now, how is this phrased? Let's see. So we have this general principle in Article 3.1, and it says, members recognize that internal taxes and other internal charges and laws, regulations, and again, who drafted this, right? Super long sentences. It's like entire paragraphs discussing stuff, right? So we have a long list of measures, again, should not be applied to imported or domestic products so as to afford protection to to domestic production. Article 3 is all about the conditions of competitions of imported products vis-a-vis the domestically produced products. Right? Are we treating the imported products worse than we're treating the national products? Right? That's the whole scope of Article 3. Article 3.1 is one that typically gives you just kind of like the gist of, or the intention of what we're trying to do with the provision, but it's not one that you would normally use to bring a dispute. If you are bringing a dispute, you will normally do it under some of the other provisions that we have in here. There's a whole discussion as well, because sometimes when you are importing some products, at the border itself, you ask them to comply with some of the internal regulations. For example, imagine I am importing, what would you like to import into Switzerland? Nobody needs anything? We can order from Amazon? No, Amazon doesn't deliver in Switzerland. Well, imagine that we want to import, I don't know, a car. Once you are bringing that car into Switzerland, Swiss Customs is going to ask you, yes, sir, please pay the tariff. In addition, can you please pay the VAT? Can you also pay, you know, you're going to be registering in Geneva. Can you also pay for the registration of this vehicle, etc.? So it may happen that at the border, they also ask you to comply with internal measures. So there was an issue. Does this make them then not covered by Article 3 or not? And then we have this note in Article 3 that says that if you're going to be dealing with internal measures, even if they are applied at the border, they still remain to be considered internal measures. Right? So the place where you apply them is not really what determines if it's covered by Article 3 or not. Is this part clear? You don't look very convinced. Let's see perhaps some of the examples we see. This is an appellate body report describing what they understood to be the importance of the national treatment principle. And for some reason, most of the cases that we have dealing with national treatment have to do with liquor or with cigarettes. And a lot. We have really a lot of this type of cases. Not only for that, but most of them are dealing with this type of issues. So this is what the appellate body said in this case of Japan alcoholic beverages. The broad and fundamental purpose of Article 3 is to avoid protectionism in the application of internal taxes or regulatory measures. More specifically, the purpose of Article 3 is to ensure that internal measures not be applied to imported or domestic products so as to afford protection to domestic production. Towards this end, Article 3 obliges members of the WTO to provide equality of competitive conditions for imported products in relation to domestic products. So this is what I was telling you before, right? It's all about whether the imported product can really compete with the domestic product. Now, one of the ways in which this is protected by Article 3 is through the issue of internal taxation of like products. So we just discussed what a like product is, right? Now we have to be careful because it turns out that what we understand to be like product under Article 1 is not necessarily the same of what we understand as like product in Article 3. The way we determine is the same, but it's not necessarily the same contours that we have. So who wants to explain to me, based on the text that we have here, what's the obligation under Article 3.2, first sentence. So there are two sentences. We're looking at the first one. What's the obligation here? We do the same thing we did before, right? So how do we split it?
First is scope of application, so products of the territory of any contracting party, so you get to pay attention that's not any party, but to the contracting ones. Then we need an import of those products of another contracting party.
And the scope in terms of the measures, what type of measures are we looking at here?
So here we talk about internal taxes or internal charges of any kind, and then we need to compare them to the internal
Exactly. So again, it's a comparison, right? A comparison of what? A comparison of taxes, internal taxes. Things like value-added tax, excise duties. These are the typical things that we are comparing here. And then the idea is, if two products are like, how should the taxation be like according to this?
So also at least alike, if not less.
At least alike or no? How is it phrased?
No, because they say any kind in excess of those, which means like more than those. So it must be at least.
So it shall not be in excess. This is a way of saying it has to be identical, right? So if, imagine I produce Coca-Cola in Switzerland and I am importing Pepsi, if we consider them to be like products, my obligation is that the internal taxes have to be exactly the same. But they are just 0.1% different. No, my obligation is that they should not be in excess, therefore they have to be the same, right? Any amount that I charge to imported products, which is higher than that of the imported products, by definition is in violation of the first sentence of Article 3.2, right?
Can it be lower?
According to this, yes.
Yeah.
Can you have a lower VAT for imported products and then punish your domestic production? You could. Who's going to complain? The domestic producers, right? So the other WTO members are not going to complain, but you're probably going to have a problem with your domestic producers. But according to this, international obligation is about how you treat the imports, and they cannot be treated worse than the domestic products, right? Again, the issue of whether they are like or not, extremely, extremely important. The consequence of two products being like is that the internal taxation has to be exactly the same. Any question? Okay, so this is the same what we already did, right? Just kind of like differentiating the different elements. Are you getting the idea of how we do it? Right? Okay. Now, this is where things get a bit more complicated, because what happens if those products are not like, but they still kind of compete one with the other? Do we have to tax them the same or not? So this is the scope of what we're trying to do in Article 3.2. Who wants to do the analysis? Okay, not you, because you have worked too much. Somebody else? Yes.
So starting with the scope of application will be again internal taxes or other internal charges to imported or domestic products. And the obligation would be
here we have a problem, right? Because it's talking about those principles set forth in paragraph 1, but what exactly do we mean by that? And it turns out that there is a note. One thing I didn't tell you is the way the GATT is written is very confusing, because you have these rules in the main text of the agreement, and then there is one annex that has these interpretative notes, notes, we have different names for them. And most of the times, you only understand what is written in the text if you look at these notes. I'm going to show you later on where you find the notes. But then, this is the note. So can you read it and tell me how does it work?
So in this case, it's not referring to taxes being in excess of, but in cases which the tax was not similar.
Mm-hmm.
So if we interpreted this, there would be like a larger margin of maneuver for this situation, because it would have more space to have a slight difference in the taxation, because it's not using the same word that is in excess of.
Exactly. So here is different. Yes.
And also, if it's not like products, but if it's directly competitive or substitutable products, it's a different analysis of it's more about the competitive relationship of the products more than the
Yes, and let me give you one example. Imagine, you remember I was telling you about importing chocolates from Iran, right? But now let's imagine Switzerland wants to protect its domestic producers of chocolates. And then if they do something with respect to the chocolates that are imported from other countries, are they like or not? You see, this is why the lawyers have so much fun, right? They spend a huge amount of time trying to determine if the two products are like or not. But chocolates from abroad and chocolate from here, are they like or not? Most likely we're going to say they are like, right? Do we all agree? Okay, but what happens if what Switzerland is trying to do is actually have higher taxation of imported candies? Are they like with respect to chocolates?
So they're not like, but probably they compete.
I think we all agree they are not like, no? A candy is not a chocolate. No consumer is going to think that they are the same, right? Now, do we care about the conditions of competition of candies versus chocolates?
Yes, I think so.
But then, how do we know if it matters or not?
So we would have to analyze whether there is competition between them.
Exactly. So we have this notion of products which are, even if they are not like, they might be directly competitive or substitutable. And then you remember the conditions we were looking at when we know if two products are like or not here? There is this notion of that economists like. No economists in the room? No? Okay. And if not, you're hiding now, no? So there is this concept of the cross elasticity of demand, which is what happens to the price or the demand for one product if the price of another product increases by 1%. Imagine, well, you're all students, you all like to eat fast food, not all the time, but then you have to survive, right? If the prices of tacos go up and they become too high, you stop eating tacos and you start eating something else, right? So there are this kind of like indirect competition between different types of products, and the idea of the cross elasticity of demand is to try to measure that degree of competition. Some products are very, very close together, others are very, very far apart, and then the demand of one has nothing to do with the other, right? Again, this is something which is done on a case-by-case basis. Is this part clear or not? Now, the consequence is, if they are not like, but they are directly competitive, do I have to treat them exactly the same? No, but the taxation has to be similar. And this is what you were saying, and how do I know if, for example, the taxation of one is 5 and the taxation of the other one is 10%? Is that similar or not? The paragraph doesn't tell us, right? So who has to find out? Yes?
And is the price of the good will be different if the taxation will be high or lower, and whether any taxes will be compared like this is the price of one good.
Yeah, but imagine that Switzerland defines that the taxation for chocolate is 5%, and the taxation for other candies is 10% in terms of the VAT. And let's suppose we did all the analysis and we concluded, yes, they are not like, but they are directly competitive in this market. So the question here is, what's my obligation under Article 3.2, the second sentence? Do I have to what? Does the taxation need to be exactly the same? We said no. But how do we know if it's similar? They have to be similarly taxed. Well, again, we don't know. There's no mathematical definition here, right? So it has to be determined on a case-by-case basis. Determined by whom? Well, the group of people dealing with whatever the dispute is, right? So this is one of those things that is very difficult to handle in practice, because whether it's 1%, 2%, 3% difference, there's no automatic answers as to whether they have to be, let's say, if the difference is acceptable or not. Is it clear? You don't sound very convinced, but let's do a break. 5 minutes, and then we come back, okay?
empieza a venir como interactiva con ellos, es mucho más fácil. Sobre todo con este tipo de artículos que ya entramos a mirar los like products en el artículo 3, se complica un poco, entonces sí es clave. Lo que pasa es que la profesora la vez pasada había tratado los like products, pero no había entrado tanto al detalle, exacto, como en las cuatro etapas, las cuatro características, y obviamente ya meterse en el artículo 3, eso sí me parece clave que entiendan esta parte de qué implica eso en ciertas cosas.
Lo que no sé es cómo va a ser Gabriel, porque normalmente, digamos, una de estas cosas duras todo un día.
Sí, yo te sé.
Es como la primera aproximación, me imagino que ya lo vuelve a ver después en algún momento.
Y al final en el examen hay, digamos que hay muchas cosas obviamente que son muy transversales, que llegan en varias preguntas. O sea, hay por ejemplo preguntas que mezclan un poco, no sé, artículo 3 con el 1, o de pronto siempre van a discutir como de forma transversal la similitud entre productos y luego excepciones, etc. Entonces como que ella igual tiende a repetir esos conceptos de clase a clase, pero sí me parece clave que
¿Vos ya la tuviste ya profesora el año pasado, digamos, solo así?
No, yo arranqué el año pasado, de hecho hace 2 clases, terminé la clase de esos años y la año pasado la hice completa, pero yo no, o sea, mi medio, no estoy en ese, mi tesis es en Derechos Humanos, Mujeres Rurales en Colombia, de la CEDAW, pero hice una pasantía en la misión de Colombia de la OMC y luego empecé a trabajar como funcionario en la otra misión, en el equipo de Derechos Humanos. Entonces, y bueno, pues con la base que tenía en la pasantía, pues salió esta oportunidad y luego pues en paralelo aquí a la función de asistente fui el co-coach del equipo de la del MUCOR. Entonces ahí sí me metí más como, claro, es que depende mucho del caso que uno tenga cada año, porque es, claro, uno se mete muy específico, no sé, artículo 3, excepciones, el año pasado por ejemplo tuvimos artículo 21, seguridad nacional súper a fondo, que me parece súper interesante. De hecho, entonces varía mucho en función de qué caso le toca a uno, pero la sensación que me da a mí, por ejemplo, porque los estudiantes del MUCOR generalmente toman la clase y están en el MUCOR también. Entonces a veces, claro, tiende a ver como ese paralelo de temas. Y obviamente, claro, ellos vienen aquí y quieren saber solamente...
Todo lo ven en función del caso.
Igual, y también lo que pasa aquí, por ejemplo, hay varios estudiantes del MIS que, por ejemplo, está aquí adelante ya fue panelista en el MUT por hace 2 años, y obviamente ya hay estudiantes que están súper avanzados y otros que, como puedo ver, nunca han visto ni derecho internacional siquiera, o a veces hay economistas o incluso de ciencias sociales.
Lo que sí me sorprendió es que no hubiera, yo pensé que todos eran abogados.
No, de hecho esta clase es bien particular por eso, y es muy variada. Hay muchos estudiantes, por ejemplo, que vienen de afuera, de hecho, yo creo que el 70% vienen de intercambio, de afuera de Suiza, ni siquiera otras universidades acá. Y de ahí, por ahí la mitad máximo son abogados. Hay mucho relaciones internacionales, hay un montón, hay mucho economista, suena un par, ciencias sociales, o ese maestría como el que dijo de sostenibilidad. Es muy transversal, es muy multidisciplinario, pues. Pero eso también le da riqueza a la discusión, entonces es interesante. Pero no, si yo creo que esa dinámica interactiva les conviene mucho, sobre todo en estos artículos les ayuda bastante, la verdad.
Vamos a ver qué pasa. Los otros son más fáciles, mucho más fáciles que este, pero sobre todo el 3 es complicado.
Es que por eso quería que iniciáramos 3, para que no lo tuvieran tan pegado todo, y luego ya estamos bien, porque ya 40 minutos es terminar el 3 y hacer el 2 que es más cortico, ¿no? 2 y luego el del
Lo hago a hacer más cortico. Problem because you are not really trying to favor the domestic production, right? So, for example, imagine you are Jamaica doesn't produce cars, and you want to have taxation of cars, taxation for all imported cars. You are not trying to favor the domestic production in Jamaica, right? So from the point of view of Article 3, there's no problem. Because you're not skewing the market to favor the domestic production. one of them is imported and the other one is produced domestically. If it's both imported, then this would not be an issue of Article 3, it might become an issue under Article 1. And the question is, are you giving a favor, privilege, or immunity to one that you're not giving to the other? If you are charging a lower tax to one than the others, the program is yes. And then if you can prove that's the case, and then the question would be, are they like products? The question is, the answer is yes, they are like products. Then the obligation is you have to treat them the same.
Then you have to.
You will need to go really through the legal text. That's why I was insisting on the how it's written, right? So you really need to fit it into whatever we have in the rule. So the cases in the abstract are very difficult to see. You really need to see something from this to be able to compare. Felipe, do I go now? Okay, guys, let's continue because I have to continue in my impossible task because I still have 2 more articles to go. There is one thing I didn't ask you. Imagine that I am Switzerland. I want to combat people from smoking, and I want to increase the tax on cigarettes to 100%. Is there a problem in Article 3 that would prevent me to do that? And then I want to increase it to 200%.
So we would treat all products from all countries in a similar manner. There is no discrimination.
Exactly. So Article 3 is very interesting because it's not about the level of taxation. The level of taxation is determined freely by the member. It can be 0, it can be 1,000%. Who chooses? The member. But once you have chosen what the level is, it has to be the same for imported and the domestic products, right? That's the whole idea. If they are like, taxation has to be identical. If they are not like, but they are directly competitive or substitutable, then the taxation has to be similar. I just thought of a different example. Imagine that you are increasing the tax on hard liquors, but then you're keeping a lower tax on beers, and it turns out that country is a big producer of beers but doesn't produce hard alcohols. Are they like? The products are beers and hard liquors, are they like? No. Beer versus beer, yes, but beer versus hard liquors, no. Are they directly competitive? Well, when people go to the bar, they choose one or choose the other. I mean, if we do the analysis, maybe the conclusion is that they are directly competitive. If the answer is yes, then the taxation has to be the same? No? Very good. But it has to be similar, and then we don't know exactly what similar means. It's something we need to look at a case-by-case basis, right? Don't be shy, huh? Now, this is just to insist on the differences between the first sentence and the second sentence, right? So we're dealing with different issues. Coming back to the notion of like products, this one is a bit difficult because under Article 1, the notion of like products is supposed to be much broader. Under the first sentence of Article 2 is supposed to be narrower. And there was a panel that was trying to deal with this situation, and they came with this very funny analogy, and they said that this concept is a bit like an accordion that expands or contracts depending on the situation. And the purpose and the meaning of what we're trying to do in each of these situations, right? So just to be careful, it doesn't mean necessarily exactly the same under each of the provisions, but the way in which we determine if they are like or not is the same. Okay? Now, there is the fourth element of Article 3 that has to be with internal regulations. I'm going to do this one very quickly. So this one is that we are supposed to treat them no less favorably if they are like products and in respect of all laws, regulations, and requirements affecting their internal sale, offering for sale, purchase, transportation, distribution, or use. And I think Gabriel already mentioned to you one of these cases we had with Korea beef, right? So there was this case where at some point in Korea they said imported beef can only be sold in this particular type of establishments, and the domestic beef can be sold in those establishments plus other ones as well. Right? So it's not about taxation. Sometimes it's about how you're able or when you're able to sell the products. And here the idea is the same. If you do it for the domestic products, then it has to be exactly the same to the like imported products. Now let me talk now about Article 2 of the GATT. This one is much, much simpler from what we were discussing before. And Article 2 has these little sentences. Much shorter, fortunately for us, than before, right? So who wants to tell me what this says? Again, I'm trying to teach you how to read it, right? So who wants to try it? Who has to do what with respect to what? Yes?
Well, the contracting party, so another state has to accord the same, well, it can't accord treatment less favorable to the commerce of the other contracting party, so it has to be also a contracting party.
Yeah.
And then the one provided in the schedule, because there's a schedule that comes with and where WTO members put their.
Exactly. So the idea is we have something called these schedules, unless you're British and then you call it a schedule. This sounds like a joke, but it's a real thing. You know, for many years we only had the European Union being represented, and they preferred the American accent. Now we have the British, and they now pronounce it schedule. So is it that we have these legal instruments where the member sets the conditions to the commerce of the other members, and once I have committed, I cannot provide treatment which is less favorable than the one I committed in that instrument. Right? Do you understand what that means in practice or not? Again, it's phrased in a very strange way, right? Let's look at this other. I don't have it here. These schedules of concessions are annexed to the GATT. I'm going to show you another sentence afterwards. They are an integral part of the GATT, and because they are an integral part of the GATT, they are also an integral part of the WTO. So when we're talking about the obligations of WTO members, we have not only those which are in our agreements, we also have individual obligations which are determined for each of the members. These obligations are determined by negotiation, and they typically relate to the level of the tariffs that they can apply. So you would have, for example, negotiations on what is the tariff that has to apply to beef. What is the tariff that has to apply in Switzerland with respect to computers? And one thing which is very interesting is that the obligations of each member can change dramatically from one product to another. It really depends on what was negotiated by them. Yeah, and we're not going to discuss how, but it really depends on how they negotiated these concessions. So these concessions are included in these big, big books that we have. I don't know, have you already seen the agreements? Has Gabriel shown them to you? No? You have never seen that purple book? No? Okay. The agreements of the WTO are contained in a publication. It looks a bit like a Bible, so some people call it like the Bible of trade. We have had different versions over the years. The latest one is that book. I'm going to ask Gabriel to bring you a copy next time. And then people think those are all the obligations of WTO members, but that's not the case. It turns out that we have thousands and thousands and thousands of other pages where we have member-specific obligations. This is a very, very strange way of having an international agreement. It used to be very unique until we had the Paris Agreement. And then when the Paris Agreement is about what? Climate change, and you're probably thinking, what is he talking about? Why climate change? Well, in the Paris Agreement, at some point, they were trying to see if you could have general obligations, and then each of the members was going to commit to do their national obligations with respect to how they're going to be combating climate change, right? So believe it or not, the way the Paris Agreement is structured is very, very similar to the way we have the GATT and the WTO agreements as well, right? So you have general rules, and then you also have country-specific type of obligations. With Gabriel, you probably discussed this year, very special for us, we're celebrating the 30th anniversary of the conclusion of the Marrakesh Agreement. So this is the agreement that has the WTO agreement. And then when this happened, back in April 1994, there was a big party in Marrakesh. This is in Morocco. And then all ministers would come to sign the final act of the agreement. And then what you have on the table is one copy of the WTO agreement. Not one for each member. No, that's one copy of the WTO agreement. It was 26,000 pages. And that's why I was asking you about the little book, because the little book we have is about 500, 600 pages. So the big bulk of the international agreement that constitutes the WTO is actually contained in those schedules of concessions. So it's hundreds and hundreds and hundreds of pages per member, where you have very specific commitments of what they have to do product by product. I'm going to show you some examples. I also told you I was going to test your knowledge of Roman numbers, right? So it turns out that each of these schedules of concessions is given a Roman number. I don't know if you have noticed, everything in the GATT has Roman numbers, right? 1, 2, 3, right? So each schedule of concessions was given a Roman number. They were sorted in alphabetical order, and then they were given a number, right? So for example, Australia. Very good. Schedule number 1, right? Brazil, 3. Canada, okay. China, people normally know how to read up to 12 because of the clock, right? 152. Good, good. 152. What about Fiji? 109. Okay, what about, where is it? Sri Lanka. Yeah, but wait a minute, you told me it was alphabetical order. How come Sri Lanka has number 6? Well, these schedules of concessions reflect a lot of history. So Sri Lanka was one of the contracting parties of the GATT, but it was not called Sri Lanka at the time. It was called Ceylon. Have you heard of Ceylon tea? That means tea from Sri Lanka, right? So that's why they have number 6. When the United Kingdom left the European Union because of Brexit, it was a huge issue because their schedule of concessions, they didn't have one for themselves. The European Union member states have one schedule for all the 20, or had one for the 28 EU member states. And the question is, once you remove the United Kingdom, how do you set that schedule? And for the UK, it was also very important, what number do we give it? So big issue for them. We look at the history, and then it turns out that they had schedule number 19. And believe it or not, when we circulated their draft schedule, it was a huge issue because we had the UK ambassador very proud in Twitter announcing, I actually took the picture, and the main issue for him was to announce that their schedule was number 19, right? United States is number 20. Okay. Schedules look like this. This one is from Cameroon. And then what happens with Cameroon? How do we read this? Okay, who doesn't speak French? Everybody else speaks French? Come on, don't be shy. So it turns out that the schedules of concessions are only in one of the 3 languages we have in the WTO. So they are either in English, in French, or Spanish. So we negotiate actually in the 3 different languages, never ever translated. So, for example, here we have the concessions by Cameroon with respect to jute. You know what jute is? It's a natural fiber. Sometimes we use it to produce sacks, etc. And then what's the maximum tariff that Cameroon can apply with respect to jute? There is this notion of what we call the bound duty. So the bound duty is the maximum tariff that members can apply with respect to a particular product. And then these bound duties are included in these schedules of concessions, right? So for example, would Cameroon be able to implement a tariff which is higher than 50% on jute? Well, they can, but if they do, then they are in violation of what? Remember, we're looking at Article 2 of the GATT, right? Just wanted to give you a more, I don't know, maybe this one speaks more to you. So this one is about headphones. And then it turns out that a few years ago, we had a negotiation of something that was called the ITA expansion. And this is the way in which the United States decided to eliminate tariffs on some of those products. So if you're buying speakers or headphones in the US, the tariff for some of them used to be 4.9%. So we have this concept of the base rate of duty. So this is where we're starting from, right? And then they said that they were going to be eliminating these tariffs and bringing them to 0, right? When? Between 2016 and 2019. So by 2019, this already passed. We know that the obligation for them is already now 0. For Switzerland, it's exactly the same. Is it clear? So what's the bound duty for the United States with respect to headphones, earphones, etc.? 0%. How do I know? How do I find it? Well, in these legal instruments, which are called the schedules of concessions. One big issue now has to do with the United States increasing tariffs on products from China. Right? You have read about that? Okay, and then there are different angles for looking at this issue. One of them has to do with MFN, Article 1, right? Because then basically it's tariffs that are levied on Chinese products which are not levied on the other products, right? There is a second aspect that has to do with the level of those tariffs. Because sometimes some of those products were already bound at 0, 5, 10%, really depends on the product, and now what the United States is applying is much higher than that. So if you're China, when they brought some of these disputes, they say, United States, you are in violation of what? You're in violation of Article 1. Are they in violation of Article 2? Well, if it's higher than what they have in the schedule, yes, and in fact China did bring this type of actions as well, right? What was the response by the United States? Remember the exceptions, right? So the United States did not even contest the whole violation aspect. Yes, say, yes, but I am allowed, and then they went directly to the exception and say, the national security exception allows me to take action which are necessary to protect my national security interest. Thank you, there's nothing else to discuss. Right, so we have some of these disputes that have taken place looking at these issues. Any question? This one on the surface looks relatively straightforward. We have had like 5 or 6 disputes looking at these issues, but then the devil is always in the detail, right? Here we're also doing a comparison, right? A comparison of what? Sorry, I made a mistake in my slides and I didn't put the the actual provision, so let's look at it. This is the provision I wanted you to see. So we discussed this one, right? We discussed 2.1a, but then we didn't discuss 2.1b. So who wants to help me reading that one, and how do we interpret it? Any volunteer? The products described in part 1 of the schedule relating to any contracting party, which are the product of territories of other contracting parties, shall, on their importation into the territory to which the schedule relates, man, who drafted this, right? There was a much easier way of drafting this, but anyway, yes. The obligation is to what?
I would say that the comparison has to be done between the tariff that was effectively applied when the product was imported into the territory and the bound rate that applies according to the schedule.
So we have a comparison between two things, right? On the one hand is now it doesn't write, the applied tariff versus the tariff which is bound and included in the schedule of concessions. But it doesn't say bound anywhere, right? This word bound duties or bound tariff is one that we use in practice, but it's not really written anywhere. And the way it's written here is that basically you have these duties and then subject to terms, conditions, or qualifications which are set forth in that schedule. And then the obligation is that they shall be exempt from ordinary custom duties in excess of those set forth and provided therein. Of all the GATT provisions, this is the one which is drafted, I think, the worst, most difficult to understand for such a simple concept, right? Which is comparing two numbers. You cannot charge more than what you have in your schedule. That's what it means. Okay? Sorry for that. I'm going to see if I change it, and in the one I send you afterwards, I include this provision, which I forgot to include. Are there any questions with respect to this, Article 2?
I
Yes.
have one question. So in the cases that the bound duty is, for example, I don't know, 20, and the WTO member is applying a duty that is below the bound duty, and that there is some water in between the bound duty and the tariff that was effectively applied. The WTO members can just go up and, until they reach the level that they have been obliged to in the schedule. And in order to do so, do they have to do anything in particular, or they are just free to get until the bound rate?
Okay, my obligation is, imagine that I have a bound duty of 5%, right? My obligation under the provision we just read is I should not exceed, right? I cannot go above 5%. Can I charge exactly 5%? Yes, because I am not exceeding, right? Can I charge 4? Yes, why not? Because I am not exceeding. So can I charge 0? Yes, because I am not exceeding, right? So there is this concept, I can see you have studied this before. There is this notion between comparing the bound, the maximum that you can apply, and then what you are actually doing in practice. And sometimes it happens, in particular with developing countries, that the bound duty is 40%, and then they are levying 5 in practice. The difference between the bound and the applied, sometimes we call it water, and sometimes we have this, I think it was German statisticians, they like to call it binding overhang. Right? So there's this technical term that we use, and some members think that having big differences between the bound and the applied are not good for transparency and for predictability. Because what happens if I am levying today 0, but then tomorrow I increase it to 5, and next day I actually put it at 3, and the next week I change it and put it again at 0, and the following week I actually make it 5%. Is that compatible with Article 2? In principle, yes, because I'm never exceeding. I'm changing it all the time, but I'm not really ever exceeding. I might be in violation of something else, but not of Article 2, right? So some members think that that difference between the bound and the applied should actually be squeezed, remove the water to have more predictability, but as you can imagine, highly contested by the other members who really, really like that water. Sometimes they have a name for that. They call it policy space. And they say, yes, but today I am applying 5, but what if tomorrow I would like to increase it and then go back to that 40% that I have bound duty? I would like to keep that possibility open, right? Everything, all of these things in particular, very, very controversial, highly contested in the WTO. Okay, let me now go to the last one. The last one I told you is my favorite. And I have 15 minutes to talk about it. So let's do this one quickly. So here I took the provision and I already divided into the different components. So who wants to help me to understand how to read this? What type of measures are we talking about and what's the obligation that I have? Yes.
I would say we talk about all the other measures like prohibitions and restrictions that we talked before.
Not just any restriction, is restrictions other than duties, taxes, or other charges, right? This defines the scope of the type of measures which are covered. Anything that smells like a tax or a duty, not covered by Article 11, right? What else?
And then in 3 it just describes how it was made effective, so it's also still on the conduct there.
Mm-hmm.
And then it prohibits this kind of measure for the importation of any product or the exportation.
So if I want to summarize that, let's suppose you want to explain to your mom what you learned today. You will tell her what? Your mom, you're not going to believe it. Under Article 11, what? Yes.
So I would tell them my mom, she's importing or exporting any kind of product in the territory of any other member state. She would not be allowed to put prohibitions or restrictions other than duty tax.
But who, your mom or the WTO members?
Well, not my mom in that case, but WTO.
The WTO members are not allowed to have prohibitions. They are not allowed to have restrictions other than duties, taxes, or charges. It doesn't matter how they make them effective. Does that sound correct? And you cannot have prohibitions or restrictions on importation or on exportation of products. That sounds so wrong, no? Why?
I think this article just tells us that the only allowed border measure among the GATT members is the duties taxations. But when it comes to quota or some other, for example, regulatory limitation, for example, import or export licenses, or other measures that limit the transactions among countries are not allowed.
Okay, let's go little by little, and then I tell you why most people are completely outraged by this provision. First of all, if we are lawyers, we're trying to understand this. What is the meaning of a prohibition? We are prohibiting prohibition, but then what's a prohibition? Yes?
The ban of exportation of certain kind of goods.
It's basically a ban, right? If your mom tells you, I prohibit that you go to that party, are you allowed to go? No, you're prohibited. That means you cannot do it, right? So a prohibition is typically when you completely ban the importation or the exportation of a particular product, right? You cannot import cocaine. You cannot import nuclear bombs. You cannot import assault rifles. You cannot import some species that are actually going to damage or bring diseases to the country. Look, according to this, you are not allowed to do that, huh? Strange, no? Okay, We discussed that a bit later. But what about those restrictions? What is the meaning of a restriction other than duties, taxes, etc.?
Maybe quota, maybe that they cannot import or export beyond a certain number of products.
And then this is where the third part helps us to understand a bit what are we talking about, right? So it talks about quotas. Do you know what a quota is? So it works like this. This is where the economists would have been happy. So basically you have a situation like this. So you have a tariff that you have to pay. This is the quantity. And then what happens in a quota is that you have a certain quantity, let's suppose 100 tons of wheat that you can import. And beyond that, it becomes prohibited. You cannot import more. Before the GATT, it was very common for governments to try to manage trade through this type of measures, right? And then you probably have heard this expression of laissez-faire, laissez-passer. That was from before, right? One of kind of like the symbols that we have for liberalism, at least with respect to trade. And it was like, governments, stop trying to do these things. Let me continue importing if I want to. The GATT has this principle inbuilt, and Article 11 is one of the places where you see this. And the whole notion is, yes, you can use taxation, yes, you can use tariffs, but you cannot just completely ban or have this type of quotas. You cannot fully ban the importation of products, right? But it turns out that quotas are not the only ones, are not the only form of restriction, right? It also talks about import or export licenses or other measures. So Article 11 is quite broad in terms of the type of measures that can be covered. And my favorite one is one case that was brought by Panama against Colombia, which is called ports of entry, where Colombia had imposed a restriction where imports of certain products coming from Panama could only be done through one particular port, which was located in the Pacific side. And then Panama was very upset, and they said, why are you doing this? This is a violation of Article 11, paragraph 1 of the GATT. And do you agree with that or not? Okay, let me see. We're going to see Felipe's country. Okay, so this is Colombia, right? So I don't know if you're aware, but Panama is a huge trading hub. It's a bit like Hong Kong or Singapore. So you have a lot of products coming from Asia that come here to this place, which is called the Zona Libre de Colón. And then from here, they are redistributed to basically everywhere in Latin America. So Panama was exporting from here, and normally these products were going to all these ports that Colombia has on the Caribbean side. And the Colombian government said, you know what? I need you to export those products only through this port, which is here, which is called Buenaventura, which is on the Pacific side. And only if you send those products through this port, you are able to enter into Colombia. Now, if we look at the text of Article 11, is that a prohibition of importation from Panama? No, why not? You can still import, no? Now, is that a restriction other than a duty, tax, or other charge? How do we know if something is a restriction, right? So this is an absolutely fascinating provision, but we don't have enough time to discuss it. Let me just give you some of the key aspects. When it comes to prohibition, the jurisprudence has said, come on, no ambiguity, we know what a prohibition is, right? It's banned. But when it comes to restriction, this one has been a bit of a pain for the jurisprudence because it's very difficult to define what exactly we mean by that. At some point, I think this was a case against Argentina. Argentina was making the case, look, a restriction is something which is so difficult for the importer to overcome that basically it's impossible to import into the country. So basically, it's a restriction means the same thing as a prohibition. Does that sound correct? Okay, any lawyer who would like to argue against that? Yes?
I mean, they wrote both words in the part of in the Article 11, so they wouldn't do it if it was the same or quite the same.
That's the most lawyerly argument, but that was exactly the argument, right? If they wanted to mean only prohibitions, they would have only written prohibition, they would have written everything else, right? And yes, the panels have agreed with that. And then we have this case, I think this was from India, it says a restriction need not be a blanket prohibition or a precise numerical number. Because on top, the name of this article is quantitative restrictions, and then sometimes people say quantitative quota, so there has to be a quota. Do we need to have a quota? No, in fact, a quota is one example. It says we can only include import-export licenses or other measures. It covers both prohibitions or restrictions, thus it is necessary to identify not merely a condition placed on importation, but a condition that has a limiting effect. It took, I don't know, like 10 more of these cases to have a better definition of what we mean by this, so I'm just giving you the conclusion. So, prohibition means that you cannot import. A restriction is that you are making it more difficult to import. And this means typically you are either increasing the cost and or you are taking much more time to import. If we go back to the case of Colombia, what do you think? Was this port of entry requirement a prohibition? We said no. Was it a restriction? If you are Panama, you say? Of course, why? Look, the products are here. I have to pay now land transport to come here, and then on top, the prices of shipping here are very, very low because everybody's already used. It's the most normal way of transporting the products. Here, there's less chips, and then basically it's much more expensive. And then on top, the, let's say, main place where the products were being sold was here, Bogota, which is the capital, and some other markets on this side. And then it just happened that this area here in the middle was controlled by the FARC, so super dangerous and costly to cross from here to the rest of the country. So super nasty case, because Colombia, the main argument that they had is they were doing this for purposes of combating money laundering. So what the way they argued, look, all these products are sold in such a cheap way that this is a way of raising cash. So basically they give drugs on the Panama side, and then these goods go into Colombia, and then basically this is a way of just raising a lot of cash very quickly in the, on the streets, right? So can we do that or not, etc. Colombia ended up losing this particular case, but ended up winning another case that happened afterwards with different type of measures. So Article 11, super, super powerful. It includes many more things that people imagine. It's not only about quotas, it can include even things like the port of entry. Any questions? It was a lot, no? Raise your hand if you think it was a lot. I know it was a lot, I'm really sorry. But then I just wanted to give you a very brief overview of these provisions. I understand that now you had a